It is raining pretty good right now.
I think it's because
We're
I don't
live.
have a window in my office.
I won't say why. I'll keep that.
Good afternoon. It's March 31st. This is the House Judiciary Committee. We're going to begin our bill hearings, we hope. And hopefully some of the, I guess one of the questions we'll have for staff very quickly is the Senate still on the floor, and did they send oh wait, looks like there's Jeff. All right, so we do have some people, that's fine. So we'll go ahead and get started with Senate Bill 270. Senator Waldstreicher is going to testify. Is Kevin Gaddis here as well, or just you? I think it's just you, so that's fine.
Okay.
Senator, if you want to testify for 3 minutes on the bill, that would be great.
Thank you, Mr. Chairman, Madam Vice Chair. In the DC area, Metro Transit Police is charged with protecting 3 separate jurisdictions, DC, Virginia, and Maryland. In DC and Virginia, the definition of indecent exposure is consistent. Maryland statute is written differently, preventing Metro Transit Police from enforcing indecent exposure on trains that happen to be in Maryland at the time. This bill remedies that so that Marylanders riding Metro will not be subject to sexual misconduct. There is no crossfile. This bill passed the Senate on a unanimous and bipartisan basis.
All right, are there questions for Senator Waldstreicher about Senate Bill 270? I guess I need to pull up the screen. Delegate Juanita Fisher.
Hi, Senator. It's so good to see you. I just had 2 little brief questions. Is it just a codified definition change, or does the penalty change at all?
No penalty change, just a more inclusive definition.
Any further questions for Senator Waldstreicher on this bill? All right, seeing none, that concludes the testimony from Senate Bill 270. We'll go now to Senator Waldstreicher's bill, Senate Bill 327. Does have several more people, or at least ostensibly it does. If we could let them into the room as well. Michael Davis, Adam Spence, Mary Beatty, May Liss Manley, and Bob.
Thank you, Mr. Chairman, Madam Vice Chair, once more. In Maryland, victims of financial wrongdoing against elderly, vulnerable, or otherwise susceptible adults do not have a specific mechanism to claw back stolen assets. Instead, under current law, they need to use a patchwork of statutory and common law causes of action in order to recover what in many cases is their life savings. This patchwork was not built to deal with the pattern and practice of these exploitation cases, which often involve caregivers and relatives. SB 327 remedies this by providing a specific cause of action for elderly, vulnerable, or otherwise susceptible victims of financial exploitation. This is the consensus work product of 2 years worth of work by a task force that included multiple section councils, including the Elder Law section and the Estates and Trust section. The Bankers Association and the Attorney General's Office were also involved and are fully on board. This bill passed the Senate on a bipartisan, unanimous basis. There is no cross-file. I ask for a favorable report.
Thank you. Could we hear first from Michael Davis, please, for 3 minutes? Mr. Davis? Okay, well, we'll go to Adam Spence. Well, there we go. Oh, no, that's not Michael Davis. That's Michael Malone. So we'll go now to Adam Spence, and we'll hear from him for 3 minutes.
Thank you, Chair. Adam Spence. I'm with the task force. I wanted to bring up just a quick issue that we were looking at today, and that is there was an amendment that was supposed to strike punitive damages from the legislation. Unfortunately, it looks like we may have actually stricken the treble damage clause, which was intended to remain in there, and I just defer that to Senator Waldstreicher. It looks like there may have been some disconnect on the amendment. But with that said, I'll go into the bill itself, and then I'll have the chairman to manage the issues on the amendment and to review that issue. But I would just like this bill, it certainly comes something very close to my heart, which is this financial exploitation that as a lawyer, I see it all the time. People come to us and their lives have just been devastated by ne'er-do-wells. I guess they call them in-laws, outlaws, and ne'er-do-wells. And we see this a lot. And so what we're doing is we're looking at section 13-603, which is the heart of the SAFE Act, which is the statute against financial exploitation. Everything else builds around this section, which creates an action for financial exploitation. 601E codifies the Maryland law that's pre-existing on financial exploitation. The first one that is an existing Maryland law is position of trust and a diversion of assets in a manner that's not fair and reasonable. That is a very common aspect of manipulation and exploitation, is somebody who actually is in a position of trust, whether a power of attorney or a joint bank account. And this law is really directed at codifying the Maryland law, but also giving attorneys fees and hopefully treble damages to ensure that there are attorneys willing to take cases to undo these wrongdoings. The second element, the second aspect of Maryland law we've codified is deceptive or false premises. This would be somebody that says, I need money to fix my car, when in fact we're just trying to take advantage of an elderly person, which I've actually seen that situation as well personally. The third is just simply when somebody doesn't have the ability to consent and the assets are diverted, and that is simply not permissible. There's been quite a few changes. The one change that came over from the Senate initially was that we did include persons over 68. There is a considerable bulk of case, or not case law, but research studies, academic and otherwise, that discuss how the younger elders are actually targeted and in financial exploitation and lose quite a bit of money every year through this exploitation, because they feel like they're on top of things, but they tend to maybe not be as on top of it as they might believe. 13604 defines who's able to bring the action. This is based on a similar law, the Power of Attorney Act, which we found very powerful in undoing power of attorney abuses, but it gives a broad list of people who can bring an act. And because frankly, a lot of these people who are exploited are either embarrassed or simply can't bring the action on their own behalf. One of the amendments was to add the Attorney General's office and give them specific authorization, which is at the very beginning of the bill. So this is where the law stands, or the existing law ends. And so what we did is, under the current situation before this.
Mr. Davis, I'm going to need you to, I'm sorry, Mr. Spence, I'm going to need you to begin to wrap up, please.
Okay. But the key provision is the attorney's fees and the ability to go after and allow people to recover the money that is taken, while at the same time recovering their attorney's fees.
Okay.
Mr. Chair, I finally got my buttons pushed properly.
All right, that's fine. We'll go to you next, Mr. Davis, for 3 minutes.
Thank you. Good afternoon, Mr. Chair, members of the Judiciary Committee. I'm Michael Davis, and I'm chair of the Vulnerable Adult Exploitation Task Force. The task force provided us an excellent opportunity to address a truly vexing problem, the financial exploitation of vulnerable adults. Our work on this bill went through a very comprehensive process that relied on attorneys from multiple sections of the state bar. We started 2 years ago, and now that work is culminating before this committee and before the House of Delegates. We would like to publicly thank Senator Waldstreicher and his staff for his hard work in getting us this far. We'd also like to thank all the individuals and organizations who have provided favorable letters of support for this bill, including the Consumer Protection Division of the Attorney General's Office. Financial exploitation of vulnerable adults is a crime of the 21st century that affects up to 1 million vulnerable adults each year. Current remedies in Maryland are generally limited to using the criminal justice system. While there is a good and proper role for criminal proceedings in these matters, the majority of financial exploitation cases are never prosecuted. There are 3 barriers to criminal prosecutions. One is victims hate to involve the police in family situations. Secondly, guilt must be proven beyond a reasonable doubt, which can be very difficult in a family situation, especially involving a victim with diminished capacity. And finally, there are limited resources available to prosecute such criminal cases. The result is that victims have very limited or no access to justice. After reviewing how other states address these cases, we determined that a viable civil response to the injustices of financial exploitation is a necessary complement to the criminal justice system. Adam Spence has already described some of the elements of the SAFE Act, and Mary Beth Beatty is going to provide to you a fact situation where if this law was in place, that her client could have received much better benefit. Milas Manley, who was going to testify, but submitted written testimony, provided background regarding the 4 amendments that have been passed with a bill from the Senate. And as Adam Spence suggested, there seems to be some confusion over treble damages being included, but clearly punitive damages are not to be part of this bill, only treble damages. Thank you very much.
Thank you. All right, we're going to go now to Mary Beth Beatty, please, for 3 minutes.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee, Senator Waldstreicher. Thank you for allowing me to testify today in favor of the Maryland SAFE Act. My name is Mary Beth Beatty, and I am also a member of the Joint Task Force. As attorneys practicing estates and trusts, we are on the front lines of this issue. All of us testifying today and our colleagues in the bar have encountered victims of financial exploitation, often by family members or other trusted individuals. In most cases, the path to justice for these victims is not an easy one. Victims may lack funds, may have diminished capacity, or simply be too embarrassed or reluctant to involve law enforcement or government agencies in their personal matters. We believe the Maryland SAFE Act provides a clear path to justice for these victims and those working for their interests. I'd like to give a brief example of a situation in my office within the last year or two. Not long ago, a client of mine was misled by one of her daughters and her brand new husband into transferring to them large parcels of valuable farmland in Montgomery County for almost $500,000 less than the true value of the property. After refusing to return the property, the daughter and her husband waged a campaign to separate her mother from her other daughters, demand more access and use of her remaining property, and threatened to withhold affection and visits with grandchildren. As a result, my client suffered not only the financial abuse, but also mental and physical decline. The Maryland SAFE Act would have allowed my client, and if she was not able, her attorney in fact, to bring suit to recover the property taken from her. With this act, cases like the one I just described will be easier to bring and easier to prove. And with the additional remedies provided to the victims, these cases may be easier to settle and should serve as a deterrent to potential perpetrators. I thank you for your time, and we welcome your questions.
Thank you very much. We'll go to Bob Enton now, please.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. I just want to thank Senator Waldstreicher and also the members of the task force for including the banking industry. Very often we are the holders of the funds that come into question. We work very closely with the task force and are in full support of the bill. You have our written testimony. Thank you.
Thank you. I don't believe that Ms. Malis Manley, I think I heard right that she had just submitted written testimony. Is that correct?
Yes, she was told that she couldn't testify, so she submitted written.
Okay, sorry about that. All right, that's fine. Are there questions for the panel? All right, seeing none, we thank you very, wait a minute, Delegate McComas, go ahead.
I'm sorry, Mr. Chair, I was slow. I was thinking, are there any other states that have this type of legislation? I mean, I want to congratulate everyone that's worked on it and Senator Waldstreicher, because I think it's a good bill, but I was just wondering if other states have something similar.
Yes, Delegate McComas, several states, California, Washington, Florida, Delaware, the district, all have some version of this this kind of bill. It's a relatively new concept. In fact, the ABA in joint effort with the Victims of Crime Unit, national organization, came up with some recommendations for what a bill like this might look like in 2017, I believe. And though it's not legislation, it's not like a uniform commission like law. It was just these are the types of things he'd like to see in a bill. And we use that sort of as a guide as we looked at the other states. We didn't follow it precisely, but we tried to make sure that we had an all-inclusive bill. And so we use that as our guide.
Thank you. Thank you, Mr. Chair.
Thank you. Are there any further questions for the panel? Seeing none, we thank you all very much, and that concludes
Thank
the testimony on Bill 327. The next two bills we're going to hear together. We'll hear Senate Bills 669 and 670 because they both have to do with the amount in controversy for civil jury trials, and I think they have the same witnesses. So it's Senator Waldstreicher and then the same people who are going to speak in opposition. So with that, Senator Waldstreicher, go ahead.
Thank you once more, Mr. Chairman, Madam Vice Chair. This bill simply alters the amount in controversy and distinction between district and circuit court. This is a critical bill as courts return to function after months of COVID closures. Because district court matters are more expeditious by an order of magnitude, this bill will allow us to resolve the COVID backlog in a way that is more just to both plaintiffs and defendants. The bill passed the Senate in a bipartisan and overwhelming fashion, 43-4. It is the same bill that Delegate Bartlett is sponsoring, for which you have already had a hearing. I want to thank Delegate Bartlett for her steadfast leadership on this issue. I hope both her bill and this bill will receive a favorable report.
All right, I was incorrect. This is a sponsor-only hearing. I apologize for that, for any misunderstanding, because we've heard the bill in the same posture earlier this year. Are there questions for Senator Waldstreicher for Senate Bill 669 or 670? The Vice Chair.
Thank you, Mr. Chair. I was wondering, Senator, could you comment on, I do have some concerns about the fact that it seems as if this passes, that there will be, some concerns about discovery. Folks won't be able to cross-examine some witnesses. They won't get records and other discovery until they actually appear at trial. They won't get medical records. So if you could comment on that. And then also, we received a letter from the Public Justice Center suggesting that this would create a hindrance for people of color and low-wage workers for actually getting a jury trial. I understand the need for COVID, but there's also a lot of other reasons folks might want access to justice, and they're suggesting low-wage workers would have a problem accessing justice, tenants, consumers. So if you could comment on that.
Sure. Most plaintiffs don't seek a jury trial. What they seek is justice. And for low-income folks, especially, who don't have the ability to be out the money to which they are owed, the expeditious nature of the district court is preferred by them because it allows them to recover the amount that they are owed, that they are victims of, much more quickly and expeditiously. And so we're not talking about criminal cases. As you know, criminal cases always have the right to a jury. What we're talking are civil matters. And for most people, the resolution, especially most victims, and certainly most low-income victims, the most just and expeditious route is through the district court.
They're saying the complete opposite. So, I mean, okay, they're saying that, low-wage workers fighting theft from their employers would have problems recouping funds, but.
Let me say why that's incorrect. So wage theft is handled primarily through the Department of Labor. If you're a victim of wage theft, you have the ability to go through an administrative process through the Department of Labor, or you can go to trial and have a jury. And so what that letter is saying is, well, these victims want a trial. In fact, that's not the case. Most victims of wage theft choose to go directly to the Department of Labor, where there is no judge, there's no jury. And the reason victims of wage theft choose to go through the Department of Labor for wage theft is because it allows them to recover their wages much more quickly. And so the same is true as it can be analogized for district court or circuit court. Just as victims of wage theft prefer to go to DOL over having a jury trial and delaying their recovery, so too do most choose to go to the district court, where recovery is much more expeditious than they would to go through a very expensive and needless jury trial in the circuit court.
Could you comment on the discovery issues that would happen in district court? And I think they would double if right now, if you have a $15,000 case and you increase that to $30,000, and then attorneys don't have access to records because they're submitted right to the court. Do you see that as problematic? Not being able to cross-examine witnesses, not being able to take depositions?
So you do have access to discovery and you do have access to cross-examination. What is eliminated in district court vis-a-vis circuit court is depositions and expert testimony. And so if you're a victim, especially if you're a low-income victim, you prefer the more expeditious route because it is lower cost. There is no civil Gideon in Maryland, as you know. We'd like to change that when it comes to landlord-tenant. But for most of these matters, low-income people don't have a right to an attorney. And therefore, the easiest, fastest, and lowest cost way is to avoid the necessity of depositions and full-on discovery.
Right, but I'm saying if you have a case, if you increase the case to $30,000, so right now, if you have a personal injury case, the records are submitted right to the court and not to the attorney. So if you increase the amount in controversy, I would think that those attorneys, to be able to properly handle the case, would want to see those records before they arrive in court, I suspect.
So if you're saying that plaintiff's attorneys prefer the mechanism of circuit court, that's not the case. Plaintiff's attorney, as Delegate Bartlett calls,
defense attorneys. I think defense attorneys would prefer to be able to see the records before they arrived in court to defend a $30,000 case.
So you are accurate that some defense attorneys prefer circuit court, but it's not because of access to records. Insurance companies prefer the circuit court because by locking out victims from getting their recovery, they create leverage for the victim to settle for lower than the case is worth, for lower than the compensation that they deserve. And so you're absolutely right. Insurance companies absolutely prefer circuit court because there is already a power dynamic between insurance companies and low-income plaintiffs. Circuit court exacerbates that by allowing powerful insurance companies to prevent low-income people from receiving the compensation that they deserve as victims. This bill puts that on par.
I just think that there is an issue here related to someone properly defending any type of case. When you're increasing the amount of controversy, which we would be the highest in the country. So when we're increasing that, we're doubling it to $30,000. I think to make things clear, we would also need to do something related to discovery, so that, I mean, you could have a case for $30,000 going to court and you don't have, the defense doesn't have an opportunity to talk to cross-examine or talk to, or look at medical records or talk to the treating physician. I mean, I do see that as a problem. I don't necessarily have a problem with increasing the amount in controversy, but I do think it should be fair. And with that, Mr. Chair, thank you. I'll stop.
Thank you, Madam Vice Chair. With respect, State Farm, all the Geico, all the other insurers that you see advertising on television are deep-pocketed defense, have deep-pocketed defense attorneys that have no problem defending their clients. So I'm happy to have this conversation further, but I'm not too worried about the defensibility of large, sophisticated insurers.
Delegate Deborah Davis.
Thank you, Mr. Chair. For the good senator, my question is about your remarks about this bill somehow helping the backlog with COVID. There is no sunset on this bill, is there? So this is a permanent, quote unquote, fix, correct?
That's correct. As you know, Delegate, we periodically have to come back every so often to adjust this number. And we have historically done so, I think, every 10 years or so recently. I think the chairman and I have both voted for a previous increase in our tenure here.
Delegate McComas, then Delegate Bartlett.
Thank you, Mr. Chair. Delegate Wallstreicher, I'm sure you've studied this quite well. Well, I was reading some of the testimony, and it was changed from 500 to 5,000 in 1990. In 2006, it went to 10,000. And then in 2010, which is only 4 years, it went to 15,000. So here we are in 21, and we want to raise it to 30,000. Some of the testimony provided did an analysis of the costs and money and inflation and everything, and we don't even come close to 30,000. One of them calculated 5,000 to 16,000 in 21, 5,000 when it was passed to what it would be today, and that said that would be 16,000. So the medical bills have not, even reached the 30,000 threshold, and then another one had it go up to 18,000. Now, one of the opposition testimony, who I think is somebody who does have a good bit of credibility because he was one of President Miller's aides a long time ago, Mr. Steerhoff suggested that he saw really no reason to justify the change. And part of it was based on the costs of the dollar and everything. And he said that there really, before we up this again, because we just did it just recently, that perhaps we should seriously consider doing some type of task force or study before we do this. Because of all the concerns that Vice Chair expressed as far as the issue of discovery, we sort of need to create some parity, because the push for this increase has really come from the trial bar, the trial attorneys, the plaintiff's attorneys, and so we haven't seen anything from anybody else really pushing for this. And I guess the question I have for you is that what are your thoughts about some of the opposition and the thought that maybe we should do a study before we, and maybe also modify the discovery rules of the district court system, so that if we do make this change, that it would be better that they don't get the paperwork the day of trial. So what are your thoughts on those two issues or several issues?
Yeah. So on what you asked last, I like and respect Mr. Steerhoff. As you know, he represents the State Farm Company. And so if you want to stand with kind of big insurers as defendants, you should obviously feel free to do so. They prefer the current system because by delaying cases in circuit court, they create leverage by which they can get victims, often low-wage victims, to settle cases below what those victims are owed. That's why large insurers support.
Well, Senator Wallstreicher, I kind of take exception with you saying that it's those poor little plaintiffs that are up in the circuit court. I suspect it's the poor little plaintiffs' trial attorneys that do a lot of advertising and are very, very good that are up there. Because I mean, you see all the advertisement for all of the different plaintiffs' attorneys on television, in the morning, in the evening, and at supper time, and at noontime, breakfast time. So I really kind of challenge that you think it's just these poor little plaintiffs, all defenseless up at court. I don't think that's the case. Do you have any data on that?
I don't know what percentage of cases are brought pro se based on these matters. In quick answer to your first question, using inflation is not the appropriate metric to measure the old number versus the new number. As many of you know, medical inflation is far and beyond what regular inflation is. Think about.
I correct you on that because they actually said that they did analyze the medical bills. So I'm not sure that that's correct.
Well, I don't have your sheet in front of me, but suffice it to say, your medical premiums are much higher today than they were 10 years ago. And to the extent that victims, especially victims of car crashes and other accidents, have very serious medical bills that come from that, we need to resolve our distinction between district court and circuit court to reflect that change.
Well, they also have PIP though too, right? And that pays for a lot of the medical bills under their insurance policy. Just saying. There's more pots of money. Thank you, Mr. Chair.
Right. All right. Thank you very much. We'll go to Bartlett now.
Thank you, Senator, for cross-filing this with me. I have a couple of things I wanted to ask you to clear up. With respect to medical records, is it usual that a plaintiff or a defendant would ask the plaintiff to sign a medical release or in fact do their own IME or independent medical examination? Is that unusual?
Yeah, so I don't practice in this area, but I don't think it's unusual.
It's not. Thanks. They will ask for a medical release and they will ask for your medical records. And sometimes they will ask for an independent. My other thing is with respect to pro se plaintiffs, I wanted to get to the support of the bill and trial lawyers. Doesn't MSBA support the bill?
That's right. They support it and support it strongly. And of course, MSBA includes both plaintiffs and defense counsel.
Right. And with respect to jury trials, this is my last question. Would you think it's more likely than not that a pro se plaintiff would be able to represent him or herself in a jury trial? Do you think they would be able to do that in a jury trial as easily as they would be able to do it in district court?
That's right. Pro se plaintiffs no doubt prefer district court because the rules of evidence are simpler, the timing is faster, and the recovery is more just.
Right. So what I'm saying is it's not likely that they would represent themselves in a jury trial.
That's correct.
Right. Because of the rules of evidence. And so they need an attorney more so in a jury trial than they would in a district trial, a district court trial.
That's right.
Right. So it's not actually something that would necessarily benefit the lawyers. It also benefits pro se plaintiffs.
That's right. Until we get to civil Gideon, which I know many of us share, pro se plaintiffs, of which there are many, would do much better in the district court than with a jury trial in the circuit court. And that doesn't benefit any lawyers.
Right. Thanks.
Are there further questions for Senator Waldstreicher on these bills? Hearing none, thank you very much. That concludes testimony on Senate Bill 669 and 670. We're going to go ahead to Senator Carter with Senate Bill 625. I see that she has logged in. I'm not sure if she's there. Senator Carter. There you are. Okay, Senator Carter, this is Senate Bill 625, please. Go ahead.
Good afternoon, Mr. Chair and Madam Vice Chair and members of the committee. It's always a pleasure to see you, and hopefully you'll share that pleasure. It'll be mutual because I'll be brief. There's no need for me to go into a deep testimony because you already had a champion on this bill, Delegate Fisher, who has gotten this bill with your support out of the House for 2 years in a row. And I'm happy to work with her on the Senate side for this really important bill to bring juror enfranchisement to Maryland. It's really, in my opinion, the last vestige of justice when it comes to full citizenship restoration for persons that are convicted of felonies. So the only thing that I really think it's important to share is the Senate committee did choose to add amendments to the bill. And I'll share with you briefly what they are because the House passed the clean bill. The Senate amendments were that still under the Senate bill as the House bill, that persons that are convicted of felonies are still would now be enabled to serve on juries but there are two caveats. One would be if they are pending cases, and that pending of a case extends beyond just if you are pending a felony, if you're pending a case where a sentence could be more than a year, which is the current law, the year standard. And the other is that that they would have to have completed their parole and probation. And I think that the House version resembled the right to vote or voter enfranchisement, which said that as long as you're not serving a prison sentence, you're released. Even if you're in parole or probation, you can vote. I think that was the spirit behind the bill. So with that, I would just suggest that, my committee felt like pending charges should exclude someone. I'm happy to discuss that either in conference committee or with the House sponsor to decide what direction we might want to go. I think the most important thing is that we do move forward with a version of this bill this year, though. With that, I'm happy to take any questions.
Delegate Juanita Fisher.
Sorry to ask the question on the bill I've worked with, and Senator Carter, thank you for leading this effort, and it's been a pleasure to work together. And this question is for you and a little bit of my chairman. My understanding of the House version of the bill is that you would have to complete the sentence and any probation, was my understanding when the House passed the version to serve. So I guess I'm just a little bit confused on the necessity of the clarification language that you'd have to be done with your probation on the Senate version, because the way, and maybe that would be a question for Claire or council. When I read the House version, you would have to be fully done with the sentence if there was incarceration and any probation that was there. So I'm a little confused about that.
I'm going to just jump in and say that you're most likely correct. I really thought in putting in the bill that the goal was to resemble voter enfranchisement. But if that is the version of the bill, then there's only one necessary clarification, which is that the Senate committee chose to put an amendment that restricts persons from serving if they're pending charges for serious misdemeanor and or felony. Now, it is still my belief that the process that we know as voir dire is more than capable of weeding out those persons that have no ability to be objective and to weed out bias, and that the standard of whether someone can be unbiased and impartial should be the standard. And I'm not sure that any of these conditions really prevail. I mean, at the end of the day, none of us can look into the hearts and minds and total backgrounds of everyone and determine what set of circumstances in someone's background precludes them from being fair and impartial. But I think this is a step in the right direction.
Delegate Cardin.
Thank you, Mr. Chairman. Thank you, Senator Carter, for filing this amazing bill that I love. I just want to be clear that the amendments on your bill prohibit you from serving on a jury if you have a charge, an allegation against you or a charge against you for serious misdemeanor or felony. Is that correct?
Yes, under the Senate Judicial Proceedings Committee amendments that were offered and passed.
Okay. And those,
currently serving the sentence for the felony, and anyone that is pending a charge for a felony or a statutory penalty for more than a year.
but based on our system of criminal justice, you are considered to be innocent until proven guilty in our system, right?
The presumption of innocence hasn't been overturned.
And as I'm sure you've had many, or you've probably handled at least a few, if not many, jury trials, you know that when a judge conducts voir dire, he will ask each and every person after they indicate affirmative on whatever he's asking, would the fact that you are, for example, have been alleged to have committed a crime, would that impact your ability to remain, to be able to make a decision just based on the facts and without a bias? Isn't that, or essentially that's what the judge would ask, right?
Correct, absolutely, yes.
So why would, I mean, do you think that the Senate is firmly set on this amendment, or is this something that is negotiable?
I'm thinking and hoping it's negotiable because I get a sense that the House is going to want to stick to pretty close to its version. And I believe in the presumption of innocence. It wasn't an amendment offered by me, but it was an amendment that passed the committee.
Thank you.
All right, Delegate Griffith, please.
Thank you, Mr. Chair, and thank you, Senator, for bringing this bill. Some of my concerns with this bill are definitely tied to guardrails. We've had lots and lots of conversations this session about the criminal justice system being broken and gaps in the system. And this puts all the pressure on the voir dire process to make sure we're keeping really bad actors off certain trials. And so there's no guardrails in this to prevent like a child rapist from serving on a trial of another child rapist. And certainly with situations where you have child molesters, that's more than a crime. There's certainly some other underlying issues with those individuals, right? This is beyond, so there's putting us in a path to create a pathway where you're going to have somebody who completed their sentence for child rape and now putting them on a jury for child rape and then giving this individual evidence of that. Is there any opportunity, just as a friendly amendment, to try to amend some of these situations off? Because we're putting all the pressure on the criminal justice system to prevent this from happening.
So my thoughts on that are, I'd like to proceed with the bill without adding those kinds of guardrails. And I'll just give you a scenario, for example. We're talking about the constitutional right to a jury trial and the fact that in Maryland in particular, in the criminal justice system, where you have a majority of criminal defendants that are black males in particular, and you have the same situation in Maryland where you have an over-incarceration of black males and those that are overly represented in the criminal justice system. And so right now, we have an unfair system where many criminal defendants aren't really getting a true jury of the peers. But I'd also say, in answer to your question, another reason that I would say no is because we're talking not only about the criminal right to a jury, but the civil right to a jury. And that would be no more pertinent than a situation where you have, a perpetual reckless driver that we wouldn't say, well, that perpetual reckless driver couldn't preside in a criminal case for a child rapist. So there's no reason to look at the actual nature of the prior conviction and make an assessment as to whether or not this person can or cannot be fair when you look at the global universe, the global universe of jury trials.
Well, certainly I wouldn't compare somebody driving recklessly to someone who's willing to rape a nonverbal boy with autism. Can you think of a single scenario where we would want a child rapist on jury? One scenario, any scenario. And if we can't think of a single one, why don't we just amend that out?
I think child rape is horrible, and sadly, we often use it to highlight the very most horrible, emotionally charged crimes that we have. But at the same time, we have sentences that have finite endings, sentences that are terminated at some point. And at that point, I believe that we are supposed to be a democratic society that says that persons that have served their sentence and paid their debt to society should now have full citizenship. We expect those people to work. We expect them to pay taxes. We hope that they will vote and participate in the political process. And they should also have that same right restored to serve on a jury. And frankly, it is up to the court or the attorneys to make a determination as to whether somebody is unfit or cannot be fair.
I think I have my questions answered. Thank you, Senator.
Thank you, Delegate Cox.
Thank you, Mr. Chairman, and thank you, Senator, for being here. I wanted to dovetail on something Delegate Cardin asked you, and one of the questions he said was regarding the restoration of the understanding of innocent until proven guilty and your thoughts on that. So do you agree that, for instance, right now, when you go to buy a gun in Maryland or in anywhere in the United States, if you have pending charges, do you believe that that should continue to disqualify someone from purchasing a gun for their self-defense or their hunting rights?
So that's not the decision to be made under this bill. I mean, that's already something that's been determined in law. That's.
But it's a logical. But it's a logical. I mean, your statement a minute ago was that you want people restored their full rights, and that would be a full right. So what would be?
I mean, I think we have restrictions on persons that are deemed suitable to have guns, to possess guns, to wear and carry guns. We have very strict laws, as you know, on who can wear and carry a gun in Maryland. So I don't think that is exactly the same thing. I think that being the right to serve on a jury is absolutely something that is for the benefit of the larger society, not only for the individual in terms of restoring full citizenship, but frankly, for all of our constituencies, that if any of people are like me that get called to jury service, usually in excess of twice a year, it helps because now we expand that pool and it takes some of the burden off of those of us that get repeatedly called. So, you know, I will tell you that a lot of our gun laws are politically motivated, and I don't like that. I think that we should try to make decisions based on what we truly think is right and wrong. But I think in this bill, I think it is right. I think it is morally right. I think it is right for our democracy to allow these people to expand this jury opportunity to people that have felony convictions. So that's what I'm here to argue.
Well, I'm sure you probably have seen, as I have, at least in my practice of law, the interest on not serving on a jury and ensuring that that right is not exercised is the number one concern for the jury pool, in my experience. So a lot of times, you know, people try to weed themselves out and it becomes a difficulty. But I guess the larger question that I'm thinking about is when you mention the right to a jury, you know, as we know, the Second Amendment is part of the Bill of Rights. It's a keystone of our Constitution. And where is there a right to serve on a jury that would be similarly protected in the Bill of Rights?
I believe it's the Seventh Amendment.
But that's for actual people who have not been convicted of felonies, and for those who have a opportunity to exercise the civil trial right. But I don't think that's a right to sit if you are a convicted murderer and you've done your time. There's no right in the Constitution to sit on a murder trial, right?
I don't think the Constitution puts a bar. I think we, the men and women of legislative bodies, have created those restrictions. And I'll tell you that, you know, one of the reasons I think this is important in this particular time is that, and you all know as well as I do, and if you paid attention to the fact that, you know, we're still grappling with the same issues that you've grappled with for a long time this session. We were in committee last night working on the House bill for police reform until close to midnight. Many of these laws, such as the restrictions on who can serve on a jury, who can vote, happened at a time where there was a specific interest in society on limiting the rights of Black people and passing laws that had disparate impact on Black people. I would actually off here have a off conversation with you, because we're really not here to talk about the gun rights. We're here to talk about the jury. And if you want to put an amendment to the jury bill, to the gun thing, that's up to your committee. I can't imagine they would want to do it because it's.
Oh, if you'll accept it, I'm game.
But you know, it's a conversation for another time, because I would actually concede, if you were interested in having that conversation, that even some of the laws restricting the gun rights were racially motivated as well. That is true.
I agree.
But I'm here right now to get people to serve on juries and open up that pool.
And I agree with you wholeheartedly. The problem I see with this is that it's a reverse discrimination, because now we're actually discriminating against law-abiding citizens in their communities who need protection from murderers by putting murderers on murder trials. And that's my concern. It actually harms the community rather than empowers them. And that would be a moral concern. But anyway, but thanks for your time, Senator.
Thank you.
All right. Seeing Delegate McComas now with a question, and this will be the last one.
Thank you, Mr. Chair. Senator Carter, I was kind of thinking about, the fact that a lot of the preliminary challenges to the jury are going to have to be made if, let's say, you get people that have a criminal history of one kind or the other. And judicial economy is very important because, we just have so many courtrooms, so many judges. So do you think that, in other words, I don't think most lawyers, at least for the prosecution, would want these folks sitting on the jury that have a criminal past. And so those folks aren't going to get on the jury. But the state is going to have to exercise some of their peremptory challenges and waste them in a sense, because the problem is if you have been convicted and you have done time, you got to have an axe to grind somewhere. And so you want somebody that's going to be unbiased, and there's no way to be able to see how that they're not going to be unbiased. I mean, it's just reflexive that they're going to be biased. So how do you get over that? I mean,
so that's interesting because I don't actually agree with the I don't agree with your assessment that anyone that's ever been convicted in the criminal justice system would have an axe to grind. Many of us on this committee and in this body over many years have gotten to know, for example, Walter Lomax. He served 39 years for a crime he didn't commit. He doesn't have a bitter bone in his body. I will say that I personally know and have had many, I wouldn't say relationships, but many encounters, many discussions over many years with people that are involved in the criminal justice system, including lifers who I've visited in our prisons on various different occasions. And I can tell you that I don't agree that those people that have been convicted, even for crimes they committed, necessarily have a bias or an axe to grind, or that they somehow would favor the defense over the prosecution. There's actually research, and I've seen it, and if it would help you, I'll have my staff pull it, because I know we read it in the course of preparing for the original bill hearing, that showed that there is no bias or inclination for people that have been convicted of crimes to favor the defense over the prosecution. And in fact, often those people go the other way. They're more inclined to conclude that someone might be guilty. So the point is that I don't think we can quantify bias or determine without knowing the individual or the circumstances what the bias might be. I actually think that is for peremptory challenges. And as you well know, that there are unlimited peremptory challenges for bias. Someone that can't be fair and impartial, there's no limit. They're all challenged. They all got to go. And if the lawyers don't do it, the court has the ability to do it.
Thank you. Thank you, Mr. Chair.
Go with this. And if we need to come back and make some modifications in a few years because something is gone awry, then we can certainly do that. But right now, I'm very excited about opening up this jury pool and giving people these greater opportunities. That's what I'd hope we could do.
All right, seeing no further questions, thank you very much. That concludes the testimony of Senate Bill 625.
Thank you.
Senate Bill 335 from Senator Sidnor. He's got two bills in front of us here this afternoon. This is not a sponsor only, I believe. Correct, not a sponsor only bill hearing. So we're going to hear from Senator Sidnor, Philip Robinson, and Judge Davis. I think there he is. Judge Davis. You know, Senator Sidnor, just for a moment to give you a chance to get set up there, you know, Judge Davis sent his son to the greatest high school in the city of Baltimore too. It's true. It's a true fact. And I know that because we were in the same class together.
You know that, I know.
Senator Sidnor, please, 335, the committee is hearing from me about policy.
All right.
Go ahead.
Good afternoon, Mr. Chair and body. Senator Sidnor on Senate Bill 335, which I know you always hear these are real simple bills. This is a bill that attempts to align the operations of our state courts with some of the same disclosures that happen at the federal level, bringing about transparency and ensuring that we know who the litigants are and what financial stakes and things that they have within the litigation. So the bill that you all have in front of you, what it does is it requires that when a party files an action, that they would have to file at least one copy of a disclosure statement that identifies essentially who has a stake in that party's litigation. I mean, that's really it. Like I said, very, very simple. The policy reasons as to why we're doing this, I will defer to my panel to speak to that, Mr. Robinson, and as well as Judge Davis to kind of talk to how this particular rule is in effect at the federal level. Thank you.
Let's hear from Mr. Robinson, then we'll hear from Judge Davis. Mr. Robinson for 3 minutes.
So good afternoon, Mr. Chairman, members of the committee. Philip Robinson. I'm a private attorney, works in Silver Spring, and I represent your constituents statewide. I've been before the committee. This is, as the Senator Sidner stated, a pretty simple bill. It will establish for Maryland state court proceedings the same identical, similar disclosures that are required in every federal court, in every U.S. district court, and every U.S. bankruptcy court around the country, and as my written testimony identifies, multiple other local jurisdictions. And Judge Davis will speak, frankly, much better than I as to why this is important from the judiciary's perspective. But I think, requiring this sort of disclosure in state court proceedings is important from a policy standpoint for all parties in the litigation to know that who is involved in the litigation when there's a corporation involved, who has an interest in it, and to make sure there is no conflict of interest or an appearance of a conflict of interest. As it stands right now in Maryland court proceedings, there is no way for me to know that on behalf of your constituents very easily, because there is no disclosure that is required under the federal in all federal court proceedings. On the Senate side, there was a good discussion and largely bipartisan support. And Senator West, I'm going to paraphrase what he said at the committee hearing. He gave sort of a history lesson that I didn't know, but this came up in the Nixon administration when it started in the federal court procedures, where a nominee for a higher judgeship position had been called into question because he didn't disclose that he had some interest with the party that had appeared before him in a lower court. And of course, there was no notice to him who the party was there and that he might have an interest. More importantly, from the public's perspective, how does the public know these things? So the bill as amended, there was 2 amendments on the Senate side to address concerns by the Maryland Judiciary. One of those was to require 1 copy of the notice to be filed in the court proceeding. And the second one was to take out the language in the original draft that would have it follow the federal rules of civil procedure, since of course it'll be filed in a Maryland court and it'll follow the Maryland rules. There was no other substantive opposition. And frankly, it's very difficult for any opposition, I think, since we're just trying to have transparency here and openness and know that there is no conflict of interest or an appearance of conflict of interest. And I'll be happy to answer any questions after Judge Davis testifies, if the committee has any.
That is just fine. We'll hear from Judge Davis for 3 minutes now, please. Go ahead.
Mr. Chairman, Madam Vice Chair, thank you very much for having me. This is a bill favoring transparency in the courts in our civil and justice system, it's really quite non-controversial. As has been mentioned, the federal courts have operated under this kind of procedure for decades, and it's never been litigated, to my knowledge. There are three clear reasons why this is a good procedure. One, lawyers and parties at the beginning of litigation or at the beginning of an appeal should know who is involved in the case, who are the real parties and interests. Number two, this kind of disclosure will save time. And why will it save time? Because otherwise, a judge, or importantly, and this is the third reason why this is a good bill, the judge or her law clerk won't discover sometimes the existence of a conflict, of an ethical challenge to the judge and or the law clerk being involved in adjudicating the case until the matter gets farther along and a motion is assigned to a judge on a circuit court, and the judge is looking through the file the night before and discovers through happenstance that some party is a party at interest in the case, and therefore the judge, under the canons of judicial ethics, can't hear the matter. And so you got to postpone it, send it to another judge. And again, I want to emphasize that the same ethical obligations that are imposed on a judge are imposed on the judge's law clerk. Now, the judge can, of course, keep a law clerk from working on a particular matter if the law clerk is disqualified, but judges and law clerks need to know that information as soon as possible. And this disclosure requirement will really help judges and law clerks fulfill those responsibilities. So I urge favorable report on the bill, and I appreciate the opportunity to address you.
Thank you very much, Judge. We'll hear first for questions from Delegate Cox, then Delegate Cardin. Committee, I have a bill to present in front of judicial proceedings, so I'm going to be going over there for a moment. The Vice Chair is going to be leading us here for a few minutes while I do that. So Delegate Cox first.
Thank you, Mr. Chair, and thank you, your honors, for testifying. And Senator Sidnor, good to see you, sir, again. I like the bill. I'm not against the bill. I just have a question as to the breadth of it, and try to get some answers on that. So I practice in federal court, and the disclosure statement in federal court, I just pulled it up again just to be sure, but it is much more narrow than this proposed law. And I'm wondering what your thoughts are on that. I mean, in the federal court system, you just simply check off the boxes of whether or not there is an affiliation with any corporation or unincorporation or other business entity, or if there's a financial interest. You don't have to list, like this would appear to say that you have to list all partners. And so here's my question. Do you think that would include silent partners and limited non-voting partners, such as law firms have dozens of sometimes? Are we going to have to disclose like dozens of partners if this were to pass with this language as it is, or is it intended to be more generic or narrow?
Well, I can start, and then maybe Judge Davis can chime in if I get it wrong. But generally, the federal rule that you're looking at, Delegate, is, as you state, it appears to be narrow, but it provides that each district court can create its own, or can create further requirements. So the bill before you is sort of the additions that have been added, not only, for example, from the United States District Court for the District of Maryland, but other district courts around the country that have added other requirements as different types of corporations have been created. As to your question about silent partners, I'm not a business lawyer, so I don't really know, frankly, what that might mean. But generally, if it's this has come up in the context of like limited liability corporations or companies where they might also have members who are another LLC. So typically in those situations, the sub LLCs need to be disclosed, and they can be quite complicated in some instances. But it's what's already happening in federal courts. So there was a case a couple years ago against the Westminster companies where this came up, and that they had removed the case to U.S. District Court for the District of Maryland. They did not want to file a disclosure of the LLC members of the defendant that identified all of the members unless it was under seal. The Washington Post and the other media outlets intervened, and Judge Berdar gave the option to the defendant of remand back to state court where there was no disclosure, or they would have to disclose in that instance. So I think, basically it's a requirement in the federal courts, and the local courts have added extra requirements. So the bill that's before you sort of following what the local practices.
If I can add to that, Delegate, you mentioned law firms, but this bill wouldn't require, of course, the disclosure of members or partners in a law firm which is representing a party in the lawsuit. The mere entry of the appearance of the law firm would put a judge on notice as to any potential conflict of interest. But as you also know, I'm sure everybody knows, the situation of the limited liability companies, the LLCs, is a particular issue because under the removal jurisprudence of the federal courts, every member of an LLC must be diverse from the opposite party. So it's critically important, again, in terms of transparency and efficiency, that yes, a quote unquote silent partner or silent non-managing member of an LLC would have to be disclosed under this bill, but also, as Mr. Robinson just suggested, would have to be disclosed once the case is removed and taken to federal court. And that's what happened in that case. They didn't want to disclose. And so Judge Berdar said, okay, well, you're not in federal court because you can't establish complete diversity of citizenship because you're refusing to disclose who your members are. And so it may read like it might be onerous, but it's not going to be onerous to identify who has an interest in a party involved in litigation, whether it's on the plaintiff side or the defense side.
Thank you very much. That's helpful.
Delegate Carden.
Thank you, Madam Chair, and thank you guys very much for coming in. A lot of my questions, and this is a little bit out of my wheelhouse, but were asked by Delegate Cox, so I'm just going to focus on. So if you have a small corporation or a small LLC, and it seems to me that figuring out how to accomplish this. Now, granted, you're required to have an attorney who's doing this, but is it going to be, first of all, is it going to be a form that's going to be available or created, or is this going to be something that's going to have to be done each time, kind of in a new way for the attorney each time they file a case or the case is filed against them?
What I think will happen most likely, Delegate Card, is that each company, each LLC will compile a list, and whoever represents that company, again, whether on the plaintiff side for some kind of commercial litigation in circuit court or on the defense side, will provide that list to the attorney, and the attorney will simply attach to a notice that's filed in the circuit court.
So the attorney, the first question they'll ask is, you're going to need to provide me with X, Y, and Z so we can apply. So that
exactly.
Would be okay.
And that would be a Word document on, an assistant's computer that would be generated.
So let me just give one quick hypothetical, and then I think it'll answer my question. So let's just say Senator Sidnor and I happen to have clerked for the same judge way back when in our previous lives. And let's say that Judge Quarles took on a case that had dealt with two corporations in some way. And I am the law clerk for Judge Quarles, and one of the companies has a subsidiary that I own 0.4% interest in. So if there's economic damages and they're required to pay, it could cost me maybe hundreds of dollars, maybe thousands of dollars, maybe, but a relatively small amount. And he's going to be required to disclose that because I could have an impact. I guess there could be a perceived or an actual conflict of interest based on my very, very small share in a company or a subsidiary of a company that's being sued or that's suing.
May I answer that?
Yes, please.
That's a great hypothetical, Delegate Cardin. I have two quick answers. First of all, it's a great hypothetical. Isn't it much better for all of that information to come out right up front in the beginning than to have the case go all the way to trial, motions practice, maybe even an appeal? And then it turns out it comes to light in some public way that Judge Quarles, as law clerk, had an interest. So that's what you want to avoid. Now, the more specific answer to your question is Judge Quarles, in that situation, I'm confident, whether he was on the circuit court for Baltimore City or later on the federal district court under either rule, he would say to you, law clerk Cardin, don't come anywhere near this case. You are walled off from this case. Your co-law clerk or an intern will assist me on this case. You are to have nothing to do with it. Don't touch the file. Do not discuss it with anybody in chambers. Mm-hmm. He would either do that or he would simply recuse himself. And this would be a judgment call for each judge, whether he shouldn't decide the case at all. My guess is he would simply wall you off from the case.
Okay. So thank you. I do want to make sure that that while we're doing something that seems like good government and smart, we're trying to create as least an onerous disclosure as possible so that it becomes relatively familiar to the attorneys who can then get the corporations to be able to abide by it in an efficient way.
So for Delegate Cardin, just to add on to the judge's answer, in my experience, that most of folks who represent corporations, in my cases, have a form that they've created to get the information from their client. They file it timely, and so once they've done it once, as the judge pointed out, they can just recreate it over and over if they need to. If it's a one-time case for someone, then they've created it if they ever need it again in the future. I would say also another aspect, this wouldn't require, this is a disclosure to be known up front. And sometimes, and I've seen some oral arguments recently where the appellate judge assigned to the panel has discovered in reviewing the briefs that they may have a potential conflict. And so the other thing that might happen is there would be a disclosure to the parties, is what I've seen at oral argument, that there might be a conflict. He doesn't think there's a conflict, but he doesn't want the parties to not know about the possibility. And then he might go further, as the judge pointed out, and say, I've walled off my law clerk who had the potential issue. So they didn't have any involvement. And once there's that disclosure, then we don't have a problem here. That's why this bill is so interesting. It's really just about making sure everybody has the information and there's disclosure.
Okay, seeing no further questions, that concludes the testimony on Senate Bill 335. Thank you. And now we're moving on to Senate Bill 587, again with Senator Sidnor. And we will have Chris DiPietro and Jacob Parker joining us. So we will give them a second to come in. Okay, Senator, they are coming in, so you can go ahead and get started.
All right, thank you, Madam Chair. Charles Sidnor, Senate Bill 587. For those of you who have worked with me in the past, you know, I've introduced bills in the past that dealt with surveillance and facial recognition, whether it be me trying to stop the use of it or the like. My more recent work has been to try to regulate the use of facial recognition by government. What I found is I continue to meet with some resistance because obviously our state uses facial recognition. So when we've put in legislation to attempt to regulate it, they've raised all kinds of concerns. So with those concerns, one of the things that we had agreed to is that all of the different stakeholders would be willing to kind of sit down and discuss some of the issues that have come up and arisen because of the use of facial recognition. You may have noticed there was an article that had come out this past summer about a gentleman in Michigan who was arrested solely on this technology. I would say that here in Maryland, when I began looking into this particular subject matter, I was told by law enforcement that facial recognition is used more as a investigatory tool, so that once they had a number of different matches and the like, they would take that and use regular investigatory techniques to then hone in on whom the suspect is. I will say that since the introduction of this bill, I've had at least one defense attorney who has said that they believe that one of their clients was arrested solely on the use of facial recognition and nothing else. So I mentioned all of this just to kind of give a framework as to what's going on. The state of Washington, they've instituted a law that was similar to what I had tried to do, but again, faced with opposition, the fallback position was, all right, let's pull all the stakeholders together and let's talk about all of the different issues that we have with facial recognition, look at what they're doing at state, local, and federal levels, see where there may be issues dealing with evidentiary matters in our courts and the like. So that's essentially what this task force is doing. I know I've heard that, task force are generally frowned upon, but I've already identified a member on your committee who I know will be a willing participant, i.e. Delegate Moon. So you all wouldn't have to worry about being recruited for any of this if you pass this particular piece of legislation. With that, I'd like to hand it over to the panel.
Sounds good. Go right ahead. Who'd like to go first?
Mr. Chairman, I guess I'll jump in and go. This is Chris DePietro. I'm here on behalf of Microsoft. We are here in full support of this legislation. We've been working with Senator Sidnor over the last couple of years on this very issue. In fact, he was the one who had reached out to us because he knew that this issue was of particular interest to Microsoft from a public policy perspective. So Microsoft has called for new laws to regulate facial recognition technology since July of 2018, well before lawmakers across the country began introducing proposals to govern the technology. The company believes that facial recognition offers tremendous benefits for security, public safety, and society, but we also think it's important for lawmakers to ensure that the technology will not be used to undermine civil liberties, discriminate against members of protected classes, or otherwise harm marginalized communities. For those reasons, in 2020, Satya Nadella, the CEO of Microsoft, decided that they would not sell facial recognition technology to police departments unless the state had governing laws or regulations on this very topic. So we think that this is very serious public policy considerations for the state. We support the task force, but most of all, there has to be public trust in the use of this technology, especially when it's being used by government entities. So with that, we support this bill. We hope that you do move forward with it. That way, this task force can come back with the viewpoints of all the stakeholders and propose some sort of legislation that can be supported by all. So thank you.
Jake Parker, please, for 3 minutes.
Hello, thank you, Mr. Chair, members of the committee, and Senator Sidnor. Jake Parker with the Security Industry Association in Silver Spring, representing providers of safety and security products in Maryland and nationwide. Our members include most of the leading developers of facial recognition in the U.S. We support the approach taken by the bill as passed in the Senate, which would bring together key stakeholders and subject matter experts to evaluate concerns about the technology and its use by state and local government, and also examine related legislation and guidelines. We know there's longstanding uses of the technology, as mentioned earlier, in our state that are important. For the past 10 years, investigators have used it to search state records more efficiently and accurately, helping identify the Capitol Gazette gunman, break up organized crime in Montgomery County, and even last year identify the brutal suspect in a brutal attack in Baltimore. Just a few recent examples. Probably also heard it was used by law enforcement nationwide to help identify the Capitol attackers earlier this year. There's also public sector uses outside law enforcement, though, that are important and vary pretty widely. For example, nearly every state driver's license issuance agency, including NBA, uses it to ensure they're not enabling identity theft and fraud by detecting efforts to create multiple identities of the same person before the issuance process is complete. Very common use. At the same time, we recognize the concerns that were mentioned earlier about the accuracy of the technology across different races, especially in law enforcement investigations, as well as the privacy and civil liberties implications of some possible applications. Some states and localities are currently experimenting with policies that would establish various restrictions. It's critical, before doing that, I think, to understand the specific implications of the different policies and also to consider the technology's performance based on the most recent and relevant science. And due to the variety of these different applications, we do urge that the bill be amended to include on the task force a representative for the Maryland Department of Transportation. I can't speak for MDOT, but I do know they've expressed interest in our conversation and being at the table because the technology is being discussed would impact their operations. But at the end of the day, we believe it's important and possible to develop balanced policies that both protect individual rights and ensure the technology is being used appropriately and in the public interest. We look forward to working with Senator Sidnor and other members of the task force if this bill is enacted.
Are there questions for the panel? We start with Delegate Grammer, then Delegate Bartlett. Delegate Grammer.
Thank you, Mr. Chair. Question for the bill sponsor, and I guess anybody on the panel. Can you speak to what capacities publicly this technology is used for? I mean, of course, law enforcement, but where are we actively using this to capture a person's face?
So from my experience, when I first introduced legislation to regulate this, I was able to go to, I think, the Maryland Department of Public Safety. They helped to run what they call a fusion center in Baltimore County is where it's located. And at that fusion center, you have local law enforcement, you have state law enforcement, and you have federal law enforcement, all in this one center that uses the technology. Generally speaking, from what I recall, they have some sort of partnership where they can pull information in from MVA, and it just if they have a certain picture or whatever that they want to use, or a person that they want to find, they then run it against that database. So that's one instance. Outside of that, I'm not certain how else it's being used.
Initially, I'm familiar with fusion centers, but initially, where is it captured? Like, how are people's faces getting into that? The gentleman mentioned you take your license picture, they're checking it to make sure one person's not getting multiple licenses. Okay, that's one place. Where else are we actually where is a person's face getting entered into the system?
You know, that's a good question. I don't have the answer to that. I would assume I'm not even gonna make the assumption. I don't know.
Can none of the other gentlemen speak to that, please?
Yeah, I can just give a little bit of an answer. I believe what happens now is that you could either use the technology to scan an existing database of photographs of individuals or video that's already been captured, or you can use it in a live scenario where there is cameras that are feeding those faces into a screening system. So the other thing I think it's important to note that this bill is just focused on the government use of these applications and how the government, but you got to understand that private sector is using this technology as well. So while I'm not suggesting that you open up the task force to look at that, but it is pretty widely used at the moment. And there's plenty of articles. You can just do a quick search on any search engine and find a bunch of articles about this subject matter and how it's being used, in some cases misused.
Okay, thank you.
Delegate Bartlett.
Thank you, Mr. Chair. Senator Sidnor, good to see you.
You as well.
My question, I know we're doing the task force and I looked over the bill about some of the things, and I know there's a report that's going to be put out. But one thing I'm concerned about, and we may not have it yet, which is the need for the task force, is the margin of error with respect to the recognition, because like you were mentioning, I think it was Mr. DePietro mentioned within the private sector is being used. Facebook often gets my face wrong and tells me that I am in a picture that I'm not in. So I wanted to know the margin of error, and if we have that data, since there has been 10 years use already, if we have that data, or is that going to be something that the task force is going to also work on and try to improve if it's a wide margin?
What we attempted to do is to draft the charge of the task force wide enough that we should be looking at all of those things. I do know that just, I think 2 weeks ago, I think it was on PBS, they had a show that followed an MIT professor who has been looking at this stuff and looking at the error rates and how the technology has misidentified persons of color. So my intention is to be looking at all of this. There's situations going on now in China, where China has been able to marry the use of facial recognition and DNA testing to discriminate against this population called Uyghurs. So, I mean, this is something that's that I hope we're going to be looking at a number of different things, but all that fall within the 6 tasks that are outlined. And I can promise you, the use and the margin of errors are things that we will be looking at. I remember in the Senate hearing that we had, Mr. Parker he touched on some of those margins of error. At least I believe he talked about the systems that we had in the state that we use here in the States. So, I mean, if you're interested, he might be able to talk a little bit more on that.
There's actually one thing I'd like to add, because I think that's a very important issue that you raised, Delegate. I think as the bill was introduced originally in the Senate, before it became a task force bill, one of the provisions of the bill was that if you're going to use the technology, that there had to be independent verification of the success rate of making identifications, particularly when it comes to Black and brown people and minorities. You don't want to rely on the company to say, yeah, this works. You want an independent organization to be able to evaluate the underlying source code and to the actual success rate of making identifications. That again, which goes to public trust. And I think that's an exact thing that we'd like to see this task force look at.
If I could add something too, on that, NIST, which is in Maryland, is actually the world leader as far as looking at the accuracy of facial recognition technology. And what they found over time is there's quite a difference between different technologies on that. And there's a wide different variety of applications. Like basically what Facebook is using is not the same thing as what you'd be using to search a large database of photos for criminal investigations, for example. Not the same exact technology. And what they found is some technologies are less accurate across different races, but other technologies are the same. So it really depends. And I think that's a good point that Mr. DePietro made about having that independent testing and actually expanding those activities as well.
Delegate Cox.
Thank you, Mr. Chairman, and Senator Sidnor, again, good to see you again, and members of the panel. So I have two quick questions. I'll ask the first one that's the most interesting for Marylanders, I should say. I see in the list of members that you're having a Washington, D.C. based university being appointed, Georgetown. I love Georgetown, but I just thought that was curious. Why not the University of Maryland? And in the context of that, what about parents and teachers, like the Maryland Parent Teacher Association, or something that would involve everyday folks who have a stake in this issue?
The Georgetown was listed because Georgetown had published a piece that really kind of kicked off my interest in this a number of years ago, called A Perpetual Lineup. So they have a center on privacy that has been looking at this and been publishing papers for a number of years. Off the top of my head, you know what? There was a professor who was at College Park, and who is now with a Bloomberg Distinguished Professor at Johns Hopkins. So essentially, the way that this is set up is those stakeholders within government and those academics that are somewhat local and easy to reach, as well as some industry people. So it was kind of put together like that, trying not to get too many members, and as well as civil rights organizations and the like.
Would you be opposed to a member of the Parent Teacher Association, or somebody that has a stakeholder in the schools, from a private angle, private public angle, rather than a governmental person?
I'm not opposed, as long as it slow down the bill.
Okay.
And I mean, and if you have someone of interest,
well, I do, because I think I share your interest in privacy. I think
Right.
Delegate Grammer does as well. So
Right.
there's a lot of us that are concerned about that. I mean, look at New York just banned the use of this technology in the schools just at the beginning of the year. So this is a big
Right.
issue, and that's a follow-up question I have. But anyway, I didn't mean to cut you off.
No. Again, I have heard that there are some school systems that have begun using facial recognition, and it's caused an uproar. If I had heard that it was something that was happening or even being considered here in Maryland, I certainly would have done it. But it wasn't a thought that crossed my mind, since I didn't think it was something that was happening here in the state.
That's great. Well, maybe we can talk offline. But so my follow-up is, and maybe for the panelists from Microsoft or Securities. So I was looking at the scope and wondering when it says that you're going to study the planned uses of the technology and then the future capabilities. And I'm wondering, first of all, if that obviously would include the use of facial and biometrics in the public and private schools. And then as a follow-up, I guess, to that, do either of you, or I guess Microsoft, do you have current stakeholders where you're actually supplying this type of technology for school systems in the world? And if so, where?
I can't speak to the school systems. The only thing I can speak with any certainty, again, I'm just the lobbyist. I don't know where they're actually deploying this technology around the world from Microsoft, but I do know that it is policy that Microsoft is not going to allow, in a law enforcement perspective, governments to use this technology until there are governing statutes for it. I think the one thing you need to keep in mind that this is a very constantly evolving technology. AI, it's all based on AI, and it's a rapid, a kind of a rapidly developing technology. So I think it's, you know, if it's being used in schools, I can imagine it is. And I think, you know, you see states like New York and southern municipalities around the country just banning it outright altogether for any use. And we don't necessarily think that's the right thing. We think that there should be sound policy governing how it is.
Just for schools.
I don't know about the schools. I can find out and get back to you.
Okay, thanks so much. Appreciate it.
I don't think there are further questions unless Delegate Bartlett was looking to come back, but I think nope, she wasn't. All right, seeing no further questions, that concludes the testimony here on Senate Bill 587. We thank you very much.
Thank you.
Thank you very much. Senator McCray is in a conference committee, so we're going to pass him and come next to Senator Patterson. Senate Bill 201. Senator Patterson, are you available here? Senator Patterson? There he is.
Yes, sir.
All right, that's fine. Senator Bill 201, go right ahead. I think you're testifying. You're just testifying, so that's fine.
All right. Thank you, Mr. Chair, Madam Vice Chair, and members of the Judiciary Committee. I do appreciate the opportunity to introduce Senate Bill 201, a crossfire bill, House Bill 1269. This bill originally intent was to seek a decrease in the wait time from a 3-year to 18-month period of which an individual could ask to seek for the expungement of their respected records. But the bill before you today has been revised on the part of the Senate Judiciary Proceeding Committee. And basically, in summary, the bill directs the courts to automatically, after 3 years, expunge the record of offenses that are currently eligible for expungement, including offenses charged under the transportation article as must appear, violators, and criminals and civil charges under Article 5 of 601 C22 of the criminal law article in case there has been acquitted, dismissal, a defendant found not guilty, or the case has been dropped with the exception if there might be some infraction relative to drugs or alcohol treatment. Additionally, a notice of the disposition will be sent to the defendant, the central repository, each booking facility, law enforcement unit, and other units of the state that have interaction with expungement of records. Again, there is no requirement to file a petition on the court under this bill for the offenses of which I aforementioned. This bill, in my opinion, will provide an avenue to those who need to get their records clean in a timely manner such that they can become gainfully employed and become full participating citizens, buying all the wonderful things that most of us buy and paying taxes to our great county and state. And so with that, Mr. Chair, I hope that this committee will look favorable upon Senate Bill 201. There are a couple amendments that the Judiciary Committee on the Senate side provided, but we forward those to the committee in advance. And at this point, I would take any question. I appreciate the opportunity.
My understanding that Vice Chair of the Judicial Proceedings Committee, Senator Waldstreicher is.
Yeah, he wants to be here. I'm not sure he's in the waiting room.
There he is.
There he is. Very good.
Right.
Thank you.
Judicial Proceedings Committee fairly pretty much changed the bill. So
yes,
Senator Waldstreicher is there, and so we'll take questions. He'll take a swing at him. Let's go with Delegate Cardin.
Thank you, Mr. Chair. Thank you, and this would really be, I think, for Senator Waldstreicher maybe, but right now, if you qualify to be able to be expunged, you have to file an expungement papers, and it oftentimes it doesn't always, but it oftentimes, depending on, will cost you $35 or something to that effect. Is this automatic expungement only for those that you're not required to file that fee along with it? And if you do have to file that fee now, are you still going to be required to file it even though you're going to get an automatic expungement?
Thank you, Delegate Cardin. I'm here to assist Senator Patterson, the lead sponsor, so I'm happy to take the question, but of course I want to give the lead sponsor the first crack here if he desires.
So the question, would you have to send in an official appeal and pay for request to have your record expunged?
Right. If these automatic expungements would qualify people who would normally have to pay a fee, and I don't know if it does, but I think some of those that you mentioned would actually would now be required to pay a fee.
They would not be required to pay a fee.
So they would not be. So is there any fiscal impact on this in this legislation?
Well, we got approval from Budget and Taxation that we could go with it.
Okay.
And Judge Morrissey as well, to whom the fee is paid.
Okay, great.
Are there further questions for the panel? I've got one. So sometimes people request they file, there's cases related to domestic violence, and they take their Fifth Amendment protections, their cross cases, and they take Fifth Amendment protections against each other. Would this allow for the expungement of those cases?
Senator?
Thank you, Senator Patterson. Mr. Chairman, this bill does not allow for the expungement of domestic violence protective orders. It only allows for the expungement of criminal offenses that are otherwise currently eligible, or possession of marijuana, which is a civil offense.
Okay, but if the cases are null prost and now in the Fifth Amendment context, it ends in an acquittal. So now, are they eligible for expungement?
Mr. Chairman, I'm just trying to walk through your example. You're saying if a person is acquitted of, say, an assault charge,
yep,
are they
where they've invoked their Fifth Amendment right against self-incrimination?
Right. So,
and they've done both sides. We've had a cross charge, and they've invoked their joint fifths.
Got it.
They would be expunged.
So this bill. So I think, let me start up front. I think the answer is yes, but this bill does not expand the eligibility for expungement. It only changes the process by which that expungement occurs. So if in your hypothetical, 3 years have passed since the acquittal on the charge, and under current law that person would have a right to apply for expungement, under the bill as it is in front of you, that person would then receive the expungement automatically. This doesn't change eligibility, just gets rid of the cost and the application.
So I have another question. So now we have a party that decides to take the marital privilege. They take the marital privilege in an assault case, and the case ends up in an acquittal. And part of our law says that you can take a marital privilege only once in a second-degree assault case, but it requires a law enforcement agency, namely the state's attorney's office, to be able to retain that information. So if the case is then expunged automatically, will the state's attorney's office be able to keep that information regarding the marital invocation?
So two quick things. First of all, the State's Attorneys Association, which I think came in against the bill, it helped draft the amendments that are in front of you and no longer oppose the bill. And then the second thing is, you would have better knowledge about what would occur under current law. But my understanding is that that person would already be eligible for expungement under current law. If that's not correct, please correct me. You have, I don't practice in this area. You have much more expertise than I do. But if they are currently eligible for expungement, then the concern that you raise is not exacerbated by the bill in front of us.
I guess a question that comes up in those cases, it may not necessarily affect the state attorney's office, but a broader question would be that by filing the paperwork, there is at least the opportunity for someone to step in if it's not automatic. But having said that, I'm going to stop, and Delegate Cardin has a further question, and I think we're going to move on.
Thank you. I wanted to spin off of what the chairman said. So if you are, if you're not acquitted, but you use your spousal, your one-time spousal immunity, and then something happens and you get either a probation before judgment or some sort of stat, you are not necessarily permitted to have that case expunged immediately. You might have to wait 3 years or whatever the case may be. The state's attorney would then have that information for that period of time and could utilize that information up until the case is expunged. If you're automatically expunging, and I guess I don't know the answer to it, but if you're automatically expunging, I guess it's.
Do you have a question, Delegate Cardin?
The question is, is the automatic expungement immediate, and therefore the state's attorney loses that information about the one-time spousal immunity privilege?
Sure. Two-part answer. First, the bill does not apply to PBJs or STETs. It only applies to acquittals and null process and not guilty verdicts. Second, it doesn't alter the period under current law for expungement. It is still 3 years under this bill. The bill doesn't change anything about what can be expunged. It only changes the method by which it is expunged.
Thank you.
And are there further questions? Seeing none, we thank you both very much. That concludes the testimony on House Bill Senate Bill 201. We're going to go now to Senate Bill 820 and Senator West. Surely we must capitulate to his desire for his bill today. Capitulation being so important in the legislative process, apparently, or at least that's what I read. Senate Bill 820, Senator West, I believe you're the only person to testify. Go right ahead.
Thank you, Mr. Chair. I'm glad you read rather than stayed up until nearly midnight to hear live. So this is...
Yes, we do read in the House. We do take people seriously in the House. And I don't believe anyone capitulates to anyone in the legislative process. But thank you very much for bringing that up. And perhaps you'd like to continue with your bill.
Thank you. So this is Senate Bill 820, which passed this on the Senate floor 46-1. The cross file is House Bill 1261, which has already been passed through the House and yesterday was voted favorably in my Judicial Proceedings Committee in the Senate. So this committee has already heard the presentation on this bill. There are a couple of modest amendments, and I believe the Judicial Proceedings staff has worked with the Judiciary staff to make sure that the two bills are conformed. If the committee would like, I'd be happy to represent the bill. Otherwise, I'm happy to answer any questions the committee has about the bill.
Are there questions for the senator? Seeing none, thank you very much. That concludes the testimony on Senate Bill 820. We'll go now to Senate Bill 15 with Senator Bailey.
Good afternoon. My first time being in your committee. Very happy to be here. Mr. Chairman, members of the committee, I am Senator Jack Bailey for the record. Senate Bill 15 requires the Secretary of State Police to provide notice to a holder of a handgun permit of the impending expiration of the permit at least 60 days before the expiration of the permit. This issue was brought to my attention by a constituent who held a handgun permit. He received no notification before the expiration of his permit, and the permit expired. As a result, he and anyone else who have handgun permits and they expire must go through the entire application process again as if it was a brand new permit. These permits do not all expire at the same time. Some expire after 2 years, some expire after 3 years. They're not like our driver's licenses that expire on our date of birth. They expire at different times of the year. I am aware that the Maryland State Police systems is now automated, but that does nothing to help the permit holders who applied using a paper application prior to October 1st, 2019. And those permits expire during the next 2 years. It is important that we implement the requirements of this bill now to ensure that all the current license holders receive notice. I am aware that the state police is concerned about the cost of sending this notice by mail. For this reason, the bill amended in the Senate by the Senate allows the notice to be sent by email if the state police has an email address on file. MSP should be able to send email notice to all permit holders as an email address has been requested on the renewal application since at least 2017. The fact that these could only be 3 years, that means every single person has the permit, they have it. I emailed each one of you this form. As you can look at in your email, you can see that it has their name, address, email, driver's license number, date of birth, and every other form so that they could get in touch with them. The state currently provides a renewal notice for other licenses that are issued by the state, such as a driver's license, car registration, trailer registrations, and boat registrations. But unlike these licenses, failure to renew your handgun permit causes you to start the process all over. You have to start all over. It takes months. You can be a business owner. You could already have a permit 1 day late and you have to start over. So it takes you back to the process where it starts and you're without that protection for months. I do not think this is a big issue. Brings to question the physical note. Last year, we put this bill in. There was many more permits because it included the dealers. This year, to get away from the note, I took out the dealers. The dealers are no longer in there, plus everything that the state police processed last year, which was 1/3 of the applications. But guess what? The price went up. It definitely brings in question about the physical note because as they say in it, when you read it, it says they have to know the date of birth. But as you can see on the form, right, it is right there for every single person. This bill passed the Senate 45-0, and I respectfully request a favorable report on this bill. Thank you very much for your consideration. I'd like to take any questions.
Delegate Grammer.
Thank you, Mr. Chair. Senator, good to see you. So I remember a couple years back, we passed a bill that we could start to process these renewals online. Is that correct?
Yes.
And this would be a simple mechanism to say, hey, please go online. There was the state police that was trying to get that so they could make this process more fluid. And this would point folks to that process online so they could have a much easier, just more effective way of doing this.
That is the current process for the people that are after October 1st, 2019.
Okay. All right. I appreciate it. Thank you.
Further questions? Seeing none, that concludes the testimony on Senate Bill 15. Senate Bill 268. Senator Bailey.
Yes, sir. Give me 1 second.
That's okay.
Thank you, Mr. Chairman, members of the committee, Senator Bailey again for the record. This bill resolves an inconsistency in current Maryland law and ensures that more offenders who commit sexual abuse of a minor are subject to existing penalties and supervision to decrease the risk of recidivism. Under current law, an offender who commits sexual abuse of a minor in violation of 3602 of the criminal law article against a minor under the age of 13 is considered to have committed a crime of violence under certain circumstances, while an offender who violates 3602 against a minor under the age of 12 is subject to lifetime supervision. This inconsistency means that a person who commits this crime against the victim who is 12 years old has committed a crime of violence, but is not subject to lifetime supervision. This bill makes these provisions consistent by requiring lifetime supervision for offenders who violate 3602 against a minor under the age of 13. The other provision of this bill addresses incidences of 3602 where the victim is 13, 14, or 15 years old. These victims deserve the same protections as those who are under the age of 13, and I have worked to expand the scope of this law to address these cases. However, during the legislative process, there were concerns raised about having the enhanced penalties and monitoring apply to younger adults who engage in this activity with older minors. In response to these concerns, the expansion of the crime of violence statute and lifetime supervision to cases where the victim is between the ages of 13 and 15 will only apply to an offender who is 21 or older. This bill makes no other changes to circumstances already in law for when the violation of 3602 is considered to be a crime of violence. Senate Bill 268 is narrowly targeted to protect Marylanders from a relatively small but significant number of offenders who have committed these very serious crimes. I thank this committee for your attention to these issues throughout this session, and particularly the work that you have already done on improving the lifetime supervision statute. This bill is prospective and does not apply to any conviction before the bill's effective date. This bill passed unanimously in the Senate, and I would respectfully request a favorable report. Any questions? I'm here.
Delegate Grammer.
I'm sorry, Mr. Chair, I forgot to lower my hand.
Okay, further questions for Senator Bailey? Seeing none. Thank you very much, Senators. That concludes the testimony on Senate Bill 268.
Wait, I have a question, Mr. Chair.
Okay, I'm sorry. Don't go anywhere, Senator Bailey. The Vice Chair, apologize.
I couldn't find my hand, sorry. Senator, I was wondering, I mean, I know you read why you changed it to 16, but are you aware that kids that are abused that are 16 and 17 are usually groomed for a period of time by the perpetrator and are probably more in danger in engaging in a relationship with a predator than a younger child?
I am familiar that all of our children are at risk, but I do know that 13, 14, and 15-year-olds are very vulnerable. And I also know the reality of my committee And there was not the will of the committee to move forward unless we were able to remove 16 and 17-year-olds.
I know you guys think 16 and 17-year-olds should get married too. I'm wondering, I mean, you started off your testimony by saying that you closed a loophole, but you guys aren't closing a loophole. So I just wanted to flag that for you because that's an inaccurate description of what you guys did to the bill.
Well, Delegate, if I could, I do agree that I wish we could catch everybody that was dealing with the 16 and 17-year-olds. But with this legislation, we can now move forward with 13, 14, and 15-year-olds. And we have been, this is the third year we have been working with this. And I would say that in the last 2 years, there have been 13, 14, and 15-year-olds who have been victimized. And if we can move forward with this, I would be more than happy to work with you on 16 and 17-year-olds. But I do think that it is important that we move forward with what legislation that we are able to move.
All right, are there further questions for Senator Bailey? Seeing none, we again, thank you very much. Now this time for real, because nobody has any questions. Thank you very much. And that concludes the testimony for Senate Bill 268. Now, Senate Bill 309, Senator Huff has sent his aide, Mr. Clark, to be here, which is absolutely fine. This is, I believe we've heard this bill on the House side already. I don't believe that we have Frank Boston here as well. But that's fine. We'll let Senator Huff's aide speak for Senate Bill 309. Oh, wait, Frank Boston is coming in. All right, so we'll hear from both of them. All right, Mr. Clark.
Thank you, Mr. Chair, members of the committee. Senate Bill 309 has passed the Senate 4 times, so the House is probably very familiar with this bill. It passed the Senate this year 45-0. It just makes a simple change to the order of business when applying for a wear and carry permit. Currently, you have to take the training, which can cost $300, and then you apply. This would make it so that you apply, you give your good and substantial reason, and if the state police say you're likely to qualify, you go ahead with the training. You do everything else that's necessary to get your permit. If they say you have no chance of qualifying, it ends it right then and there. You don't have to pay for the training or pay for any of the other expenses. So this will save Marylanders money. With that, we'd ask for a favorable report on Senate Bill 309.
Boston.
Mr. Chairman, members of the committee, I'm Frank Boston. I'm here on behalf of the NRA, and I'm working this computer by myself for the first time, Madam Vice Chair.
We're all impressed.
Yes. I'm here today in support of Senate Bill 309. We thank Senator Huff for putting it in. The NRA has submitted written testimony as well. This bill gives preliminary approval of a handgun wear and carry permit contingent on subsequent completion of the certified firearms training course within 120 days of receiving the permit. You still have to undergo and complete everything else under Section 5306A to make sure you're not a danger to society and make sure you have a good and substantial reason to carry a handgun. You know, the COVID pandemic has made it difficult for some people to obtain this firearms training. And because of social distancing, classes are smaller. The bill allows more time for permit holders to choose a safe time and setting to complete the training course. Further, the need for access to self-defense sometimes can be immediate. For these reasons, we ask for a favorable report.
Are there questions for the panel? Delegate Cox.
Thank you, Mr. Chair, and good to see you, Stephen. Say hi to the senator for me. I have a quick question for Mr. Boston.
Yes, sir.
Is it your understanding that this, which obviously is a unanimous bill in the Senate and has been, that this would actually help low-income individuals to make sure that they have some financial security when they're trying to pursue their own safety? They want to, not have to pay the hundreds or thousands of dollars up front. They can get a decision as to their likelihood of receiving a permit?
I think, the bill allows them time, allows everyone time. If they need, if there's the cost of the training program, you got 4 months to come up with the money, or you can shop around to find one that's more affordable and not be forced to, do it within a lesser time frame.
But you think it'll especially make sure that there's more access to justice for low income?
I would hope so. Low income and everyone. It's just more access to justice, and for someone who needs to, who has a good substantial reason to obtain a handgun.
Right. Thanks much. Thanks for bringing the bill.
Thank you. Yep.
Vice Chair.
Thank you, Mr. Chair. I actually just wanted to flag for Delegate Cox, based on his questions, that the reason this bill probably doesn't get unanimous support over here is because, and you can check with your senator on this, our process is very flawed. So that's probably why he can't get anything done over here. Thank you, Mr. Chair.
Much about that flawed process lately.
Terribly.
Further questions? Seeing none, thank you all very much. And that concludes the testimony for Senate Bill 309. We're going to go now to Senator McCray, who is joining us after being in a conference committee and now has come out of the conference committee. He's going to speak to us about Senate Bill 525. There are people who are going to speak in opposition, being that while we heard a similar bill, actually we were secondary on a similar bill. Let me just very quickly procedurally. House Bill 222 came to the Ways and Means Committee and we were secondary. Originally, I think this bill might have been more in our bailiwick somehow initially starting out, but in any case, it's here. Ways and Means has interest in this legislation as well, although they're not here with us this afternoon, but we'll be communicating back and forth to Ways and Means as well. So with that, Senator McCray, go ahead for 3 minutes.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. I'm surprised that anybody would be in opposition to this bill. But first, this bill simply started out as an early voting precinct for Baltimore City Intake Center. Obviously, I had to work with the mayor's administration, Department of Public Safety, and the local and state board of elections. So that's 4 different people or organizations that have some similar interests. What I did was I actually worked with them and we got it down to a drop box. There are about 700 people that are at the Baltimore City Intake Center. This is an issue that I follow very closely, being the sponsor of House Bill 980 back in 2015 for those folks that are on probation. The importance of why this is important is because folks that are at Baltimore City Intake Center have not been found guilty of a felony. They also may not can pay their bail from that standpoint. I followed the June primary election 2020 very closely, Mr. Chair, and what happens is we're not treated in the same manner that we were treated in. But I worked very closely with the state board of elections, that local board of elections, and they were all given a ballot at their location because the Department of Public Safety creates a list in March for the elections that are held in April. And then in October, they're already created a list of people that are eligible to vote. So what we did was working with them, we created and found the solution. It passed out of the Maryland State Senate. We're currently here in the Maryland House of Delegates. I understand that there may be a bill that's similar, but I've never seen where we couldn't walk and chew gum or just doing the same things that serve similar purposes. So I would like for the committee and hoping that they pass it in the posture and get across the finish line because it's people, 700 people, if it was the last election, that would have been able to benefit for something like this right at the Baltimore City Intake Center. And I'll take any questions, Mr. Chair.
All right. Are there questions for Senator McCray? Delegate Grammer.
Thank you, Mr. Chair. Senator, good to see you. As a technical question, this is a ballot drop box. Is that correct?
Yes, sir.
So the assumption is they have the ballot with them at the intake center?
So the assumption is that they work with the state. First, I should have acknowledged inside of my opening remarks that this is a state agency. So every other local jail is controlled by that local jurisdiction, but the Baltimore City Intake Center is a state agency. So this is the state of Maryland. So what happens is that because they did not get their ballots in the June primary, so the June primary, Delegate Grammer, I worked very closely with the state board of elections, our local board of elections. They walked through and handed out ballots to everyone, because you got to remember, we were mailed ballots to our home, but they were not treated similar. They did have a process. If an inmate or detainee would have requested an absentee ballot from the respective correctional officers and things like that, they would have immediately given it to them. They should not have had to request it. They should have been given it to it, because they all came to our homes in the similar posture. And that's all we asked for. And they did just that. They worked with Department of Public Safety, Secretary Green, and Linda Lamone at the State Board of Elections, Armstead Jones, all coordinated to make sure that happens.
And that was in the pandemic, they should have gotten them just as everybody else. So going forward, would the bill, if implemented, automatically send ballots to the detention center? Does the bill work that out? How are you going to know if somebody's in an intake center? They could have been there for a day.
So what happens is there's actually a list that's created, as stated. I said this in my earlier testimony. So they know how many people are in their facility who have the right to vote. And as stated, it was 700. They stopped that cutoff, and they're not telling you can't vote, but they create a list right there in March. It's right when the voter registration deadline happens is when they for October and for March. They've sent these lists. I said to Robert Green, if you create these lists, why don't the State Board of Elections have this list, and then help them to coordinate? And the State Board of Elections had it, and then they made sure that those folks got those ballots from them.
Okay, thank you.
Thank you.
All right. Delegate Bartlett, then Delegate Juanita Fisher, then Delegate Cardin. You could be succinct, that would be helpful. Delegate Bartlett.
Thank you, Mr. Chair. I'm always succinct.
You are. That wasn't pointed at any one person. It's just generally, and I guess the chair is getting feisty and annoyed. Not at it here right now. Delegate Bartlett.
Thank you, Mr. Chair. Senator McCray. Very quick question. Okay, so we passed House Bill 222, Value My Vote. It was a great bill. One of the only in the nation, probably. So that bill would have at least 60 plus drop boxes, Baltimore City included. Why do we have a need for the Senate Bill 525, your bill?
So let me be very clear. I did not know anything about a Value My Vote bill. I think I heard from the House sponsor about a week ago. So I heard about the House sponsor asking questions about that. I'm not on the committee of jurisdiction that has a voting bill, so would have went through EHE. I serve on B and T. So my interest was, because I've always followed this bill, Delegate Bart, not followed this bill, but this subject matter. So let me be clear. In 2015, I know I was in the House at that moment. I championed a bill to restore voting rights, parole, and probation. So every year after the election, I've always followed these specific issues. I was very critical in the issue during the pandemic, because it changed the voting process just in general as a whole for that assumption. So once I dug into it, I realized that the list was there. It started out as an early voting precinct. So what I would have liked to have is, I think that early voting precincts, specifically in the city of Baltimore, should be in our specific Baltimore Intake Center. There's enough people there. There's 700 people there. What happens when you have a cost of doing business, there's always a manner of negotiating with these four agencies. So I had the administration to negotiate with. I had the Secretary Green, Department of Public Safety, to negotiate with, the local board of elections, and the state board of elections. Two of them, the local board of elections is concerned because there's always a split cost between the state and the local jurisdiction from that standpoint. The Department of Public Safety has an interest because they want to make sure that they're in control or know who's going in and out of their facilities. And obviously the mayor's office, because they pick up the local board of elections, ultimately falls on the local taxpayers back home in Baltimore City. So when we got to negotiations, this was a comparable negotiation. And I think that this bill came out 2 or 3 weeks ago. So I'm not sure where the other bill was at that point in time, but this was a negotiation amongst those 4 agencies to figure out how to move the ball forward on this specific issue.
Thank you, Senator McCray. If I may just have a quick follow-up, just really quick. So doesn't the value of my vote encompass, or wouldn't it encompass Senate Bill 525? And I've put in election bills as well in the past. I put in an election bill, but I didn't this year because I saw what was already out there. But wouldn't it encompass it, because that's for the entire state, whereas this one is just for Baltimore City?
So I started off, Delia Bartlett, like, I don't know what happens with the negotiation of other bills. So I'm not sure if it started off in this posture, but let me be clear, there are 2,000 bills that's introduced. The one that I was concerned about was Senate Bill 525. And I think I said in my testimony, I don't understand why we couldn't do both. I'm actually in support of enfranchising the vote as much as possible. So I don't know why we would argue against one bill versus another bill if they're both trying to get the ball up the field, is what I would say.
I understand. Okay, thank you.
Delegate Juanita Fisher, then Delegate Carden.
Thank you, Mr. Chair. Hi, Senator McCray. It's always good to see you.
Hey, Delia, always good.
I just had a question about the awareness in your bill. Well, with COVID, I haven't, but I do end up visiting our prisons across our state in my day job more than others. And sometimes folks in that situation, they don't know that they're still, eligible to vote. They would have no idea. So just maybe like the drop box alone might not be enough. Does your bill have a mechanism to make folks behind the walls aware that they have that ability to vote depending on their situation?
I believe so. There's already regulation because this one right here is a state agency. So we operate a little bit different than our local jurisdictions would. So there's already regs that says that this is going to be passed out from the COs and things of that nature. I think that Robert Greene, in my opinion, is a very progressive secretary in reference to the Department of Public Safety from that standpoint. Could there have been more done? Yes, I do, which is why I made sure that I coordinated with the State Board of Elections. I think that Robert Greene was doing what he could do, but I think that it could have been a lot more done from our respective State Board of Elections. But to your question in reference to the notification, I think that the notification does happen already, but I do believe that there are notification pieces inside of my bill. I can't see the exact page number, but making sure that we put that from a statute standpoint and move from a regulation standpoint. I believe that the Department of Public Safety is already in support because they already do that piece of it.
Okay, thank you so much, Mr. Senator McCray.
Yes, ma'am.
Delegate Carden.
Thank you, Mr. Chair. Senator McCray, thank you for what you did. By the way, in 2015, I was the lead sponsor and the floor leader on the bill to restore voting rights to ex-felons back in 2009, and you had to finish the job for me, so thank you. Isn't it true that we're requiring, at least in 222 and in other legislation, we're requiring 24/7 surveillance of drop boxes? And the answer is yes. Isn't that true?
It is true.
Yeah.
I think that I'm a little bit.
You don't know. I know you don't.
I don't know.
But wouldn't it be the case that because this would be a Department of Corrections facility, that it would be very easy to accommodate the 24-hour surveillance on this bill?
I believe so. I've talked to Secretary Greene about that too, and all they're asking to do is put it in front of a camera that they have at that facility.
Right. And so a lot of the concerns that were raised perhaps by the opponents of this kind of legislation, of that there's not enough security, that wouldn't pertain to this bill at all. This would be a real good reason why this is the kind of legislation that actually shouldn't have any opposition at all, right?
I will hope that the Secretary Greene in his shop is not here opposing the bill, because I know that we did work it out. So I usually we get committee testimony, and I haven't gotten any committee testimony from Judiciary, but I would pray that they are not in opposition to this bill, because it was worked out.
All right. Seeing no further questions, we thank you very much, Senator McCray, and we're going to go. Could we call them in, please, to 5 people who wish to testify in opposition? but whom I think we're going to hear similar stories from. Nicole Hansen-Mundell, Christopher Dews, Monica Cooper, Tia Hamilton, Antoine Quarles. Or maybe just one. Or two. All right, I see Mr. Quarles. Let's go ahead for Mr. Quarles. Mr. Quarles, go ahead.
Yes, I'm here. I'm here.
Go ahead.
My name is Antoine Quarles, founder of Hope Baltimore. Madam Chair, Sir Chair, can you hear me?
Yeah, I can hear you. You need to go ahead. You have a couple minutes.
Okay, my name is Antoine Quarles, founder of Hope Baltimore, helping oppressed people excel, and also community ground value my vote training person. And on the committee, I oppose House Bill 525 because it only gives the mimicking part of what House Bill 222 has already established, but the impact that we approved, we serviced over 5,000 education packages, collaborated with many different organizations to go statewide, 21 detention centers. We registered people, and they was enthused by being able to know that they could register to vote at that time. You know, and being that this House Bill 222 also nullifies that with their release, they will be notified with their parole and probation officer that they can register to vote and will no longer be burdened from not being able to vote as a convicted felon. So this is why I oppose 525 bill, because it doesn't equate none of those impacts.
Nicole Hansen-Mundell, please.
Greetings. For the record, my name is Nicole Hansen-Mundell, the Executive Director of Out for Justice. Just for the committee to know, you did a really good job by passing HB 222. This is a bill that the Senator McCray, seconded this same bill last session. This is a piece of legislation that Mr. McCray was also notified by the many advocates across the state. In fact, it was the advocates on this call who alarmed Mr. McCray that we needed to go further in terms of voting access for our individuals pre-trial. And it was the work of these groups that the State Board of Elections put in their 2020 report. They highlighted that for the first time in history, they engaged the incarcerated citizens statewide. And because of that, they work with Out for Justice. I want to let you all know that you're doing a really good job at choosing to support HB 222 because HB 525 is really all, you know, what 525 is nothing but a little small portion of what's in 222. 222 ensures that we have an ombudsman, that's the State Board of Elections that we work with closely. In fact, we worked so closely with the State Board of Elections that they participated in crafting this language back in November. This was a bill that was filed early. 525 kind of was filed a little late in the game. And so the State Board of Elections is in agreement with us in terms of an ombudsman, notifying folks probation and parole, the 24-hour drop box that you all are talking about with the camera at the top, making sure they have a statewide program. HB 222 gives the foundation around how the State Board of Elections is going to operate statewide, Mr. Chair. The HB 222, the Value My Vote bill, also includes reporting mechanisms that I don't really think 525 allows for. And this is all supported by the League of Women Voters, the Job Opportunities Task Force, all the directly impacted organizations stand in support of HB 222. And we think, yes, we can chew gum.
Thank you very much. You will wrap up.
Must pass the best bill. Lastly, Mr. Chair, the National Organization's Campaign Legal Center was quoted as this would be the #2 bill in the nation that affirmatively ensures voting access for all individuals in our prisons and jails.
Thank you very much. Mr. Dews for 2 minutes.
Thank you, members of the committee. My name is Christopher Dews, Policy Advocate for the Job Opportunities Task Force. I want to thank you all for the opportunity to testify. Most of my comments have already been made actually by Delegate Bartlett and as well as Nicole Hanson-Mundell. So I'll just say this very quickly. As you already know, this bill, Senate Bill 525, only one jurisdiction, House Bill 222, which is an exhaustive effort that's been worked on by many different partners over the course of years, will cover most people throughout the state. Kiana Johnson, who was supposed to speak as well today, has her entire station is in Prince George's County, and this bill would not actually do anything to submit any type of relief to the committee, to the population that she's working with. So we just think that House Bill 222 is the better bill. Instead of trying to limit down to just one jurisdiction, this can actually spread it out. And we do thank Senator McCray for the conversation, but we just think that the bill that you guys have already passed and already made moves on is the better option. I won't belabor any more of your time, and I want to thank you guys for the opportunity to testify. Thank you.
Tia Hamilton.
Yes. Hello. How you doing, guys?
Okay, go ahead.
Let me tell you how important it is for me to stand behind House Bill 222 and oppose Senate Bill 525. Is that I'm driving through a thunderstorm in Louisiana on the college shore with my son. This is how important it is for everyone to understand that this is another form of voter suppression. Why would we only want 7% of the prison population in Baltimore City in prison and jail population when House Bill 222 takes care of at least 90% or more of the whole state of Maryland of the jail and prison population? It absolutely makes no sense that we're going to seclude the whole state of Maryland, but Baltimore City, even the surrounding counties in Baltimore alone. It's very important that we understand that the voices shall and will be heard from all over Maryland, for men and women that are incarcerated, because they too have to follow the same rules that we want them to vote for and want to vote for when they return. So as a returning citizen and even incarcerated, it's important for House Bill 222 to take effect, and we oppose Senate Bill 525.
Thank you. The Vice Chair with a brief question.
Thank you, Mr. Chair. This is for Ms. Hanson-Mundell. How are you?
Vice Chair.
Good to see you. Well, first, actually, Ms. Hamilton, I just want to say thank you. You're on a college tour. I appreciate that you dialing in is important. And as a mother, I respect that. I just wanted to, Mr. Chair, kind of lift up Senator McCray. For those of us who were here in 2015, and this sounds like it was kind of combative bill versus bill when it didn't need to be. For those of us that were here in 2015, we know that he led a very impassionate speech on the House floor and passed legislation that allowed 40,000 ex-offenders in our state the right to vote. And so I just, for our newer members, wanted to uplift that because they might not have been aware of that. So I appreciate the work on 222. I appreciate Senator McCray's work. Wish everybody could have worked together, but thank you, Mr. Chair. Just wanted to put that out.
No, we do too, Madam Vice Chair. And many of the members on this could attest to the fact that we did reach out to the senator to let him know back during the during the 2020 election that we plan to do something. And Common Cause reached out to the senator. We Out for Justice co-chaired that very coalition that you're talking about, Vice Chair. But what we did realize is that there were some missing pieces out of that bill. We were so excited to get voting rights for individuals who are coming home from prison and jail that we missed the component around accountability, reporting, what agencies.
Right, I hear you. I just wanted our newer members to understand what a huge lift that was for Senator McCray back then. That's all.
It was a lift for all of us. That was a piece of legislation that impacted all of us. We were all a part of that. We were all fighting really, really hard to ensure that. But we know that we have to do more, and some things was left left out of that bill, including, reporting and accountability. The State Board of Elections Vice Chair said it themselves. We were on a work group with them. They said they had never done anything like what we got them to do last year. Senator McCray talked about this list, Vice Chair. I am the sole person who got the list for the State Board of Elections. Nikki Charleston can tell you, I delivered her 7 jurisdictions. I went to 7 wardens across the state, and they delivered me the list that I then delivered to the State Board of Elections. They can attest that themselves. So this idea that we are not trying to work together, we are. And everything that the State Board did last year was
Good. I'm glad to hear you guys are working together. Thank you, Mr. Chair.
Thank you very much. Seeing no further questions, that concludes the testimony on Senator McCray's bill on Senate Bill 525. Thank
with
you.
Kiana, I think you had another person, Vice Chair.
I don't have another person in the room, but thank you very much. The committee, that concludes the testimony on bills for today, March 31st. Subcommittee chairs, please. We're going to have a meeting immediately after this. Committee, we're going to be voting at 7:15 p.m. tonight, 7:15 p.m. tonight. We will have a voting session and we'll be back on the air. All right, with that, that concludes testimony today for the House Judiciary Committee. Again, 7:15 for a voting